Region Community Legal Services. And tonight we're going to be talking about sexual harassment in the workplace and what your rights are and things you can do if you've experienced workplace sexual harassment. And so thank you for joining me. Like I said, you're welcome to ask questions as we go along. Our session is recorded. So if I say anything that's unclear or you want clarification, please feel free to unmute or put your question in the chat. I do want to save time at the end. We're going to go through a case study. So I've got an example that we can go through and we can have a discussion and have time for questions. So now I'm going to pass it over to my colleague Evangeline from the clinic, and she's going to offer a land acknowledgement and tell a little bit about the services that we offer at the clinic. So I'll pass that over. Thanks.
Thank you. Hi, everyone. My name is Evangeline. I am a community development worker here at Waterloo Region Community Legal Services. I just want to welcome everyone and thank you for joining today for our virtual presentation. So before we begin, I just want to offer a land acknowledgement. So although we are meeting virtually today, I want to acknowledge that we are presenting on the traditional lands of the Anishinaabe, Haudenosaunee, and Neutral peoples, and we thank them for allowing us to do our work on their traditional lands. We just want to acknowledge the land to express gratitude to the Indigenous people who have lived and worked on this land historically and presently. It's important to recognize the long-standing history of colonization and genocide that has brought us to reside on this land and to seek to understand our place within history. As such, land acknowledgements like this are meaningless without action. We all have a continued duty and a role to play in reconciliation. So I just want to encourage you to learn more about the ways that you can participate in reconciliation. And we encourage you to do some more research on colonialism, attending events and opportunities to engage with Indigenous communities, as well as engaging in self-reflection. I'm going to include a list of resources in the chat box after this to help you just explore further ways that you can engage in truth and reconciliation. And there will be a link as well to a native land locator site. That's what you see in this slide here. You can use it to map out Indigenous territories, treaties, and languages. And in learning this, we take a step forward towards strengthening our spiritual bonds with the people that are on this land and its people. So we can go to the next slide. So I'm just going to give a little bit of background information about our legal clinic. Waterloo Region Community Legal Services is a nonprofit organization funded by Legal Aid Ontario. We provide what is called legal services and support to residents of the Waterloo region living with low income. So some of our services include assistance with housing, such as tenant rights and responsibilities. We also help with appeals to the Social Benefits Tribunal for Ontario Disability Support Program. We also assist with applications and appeals for Canada Pension Plan and Disability. We also deal with employment law and employment insurance, immigration law, consumer protection, the notarization and commissioning of documents. We also have an Indigenous Justice Program, which seeks to support status and non-status Indigenous folks in the community. And we also have the Sexual Harassment in the Workplace project, which is what we're presenting on today. And we also do a lot of public legal education, such as the one that we are doing now. There are 74 community legal clinics across Ontario, and our mission is to ensure that everyone in our community has equal access to justice and the legal supports necessary to improve their quality of life. So I'm going to turn things to Ashley now. If you have any questions throughout the presentation, you can put them in the chat. You can raise your hand, or if you don't feel comfortable, you can ask questions at the end, and I'll turn off the recording so that folks can feel more comfortable.
Okay, great. Thank you so much. So We're going to start off by doing some myth busting. So I've got a few questions we're going to set up as polls to get you starting to think about sexual harassment in the workplace and things that you may think that may not be accurate. And we'll talk about all of those things. We're also going to talk about key concepts. So what are the definitions of sexual harassment? What laws apply in Ontario? And we'll talk about some examples. We'll talk about the definition of the workplace and what happens if something takes place outside of the workplace, or what if something happens within the social media realm or virtually, and if that can constitute workplace sexual harassment. Spoiler alert, it can. So we'll get to all of that. We're going to talk about your employer's obligations to keep you safe in the workplace, things they have to do, like having policies and providing training and conducting investigations if any complaints are made to them. And we'll talk about what options are available to you to report sexual harassment if you experience it, options that exist within the workplace, and then possible legal options you can take to pursue legal action if something happens to you. And I've got an activity, which I think is a really great way to sort of cement the learning that we're going to do today, because it gets you thinking about the concepts that we've been talking about. So, you know, talking about sexual violence can be upsetting. So if you need to take a break and you want to step away, please feel free to do so. I've got a list at the end of the presentation of resources in the community if this has been triggering or upsetting or bringing up any emotions or feelings for you. There's some really great resources, including the Sexual Assault Center, which has a 24/7 line that you can contact if you need some support. So we've got that at the end. So I'm here today with the project, Sexual Harassment in the Workplace project, and our clinic has received federal funding for 5 years to provide training and free legal advice when it comes to sexual harassment in the workplace. So I'm able to provide this sort of training through provided by the federal government, and also if you've experienced workplace sexual harassment and you have any questions or you want legal advice, we're able to provide free legal advice to anybody through this funding. So please contact the clinic, or you can contact me directly, and I'll put my email address in the chat. If anyone has any questions, I'd be happy to talk to you, let you know what your options are and steps that you can take. So I am not able to give legal advice today in this training session, and nothing that I'm saying today should be construed as legal advice. This is just information about the law as it exists in Ontario. I'd also like to just encourage everyone that if you're going to be asking questions or sharing, please be respectful, and we want this to be a non-oppressive, safe environment for folks to learn. Thanks. Okay, so our first true or false question, I'm going to have Evangeline launch the poll for me if she can. So the question is, men experience sexual harassment at work as much as women. Do you think that that is true or false? And so I think we'll go through, I think 3 questions have launched at once. So I'll ask you all the questions and then we'll go through the answers. Is that right? Yeah.
Yeah.
So no, that's okay. Thanks. So then the second question is, employees in the service industry experience the most sexual harassment. Do you think that's true or false? And I should say the answers are all based on reported statistics that we have available to us. And then the third question is, workers have experienced an increase in sexual harassment during the pandemic. Do you think that's true or false? So go ahead and take a few minutes to answer, and then we'll go through. Okay. So it looks like most folks have answered. No, only 40% have participated. So we'll give everyone another second.
I cannot answer that question on the screen.
Oh, it's not working. Okay, sorry about that. If you want to, if you also want to just write your answers in the chat, you can just write 1 for the question and then write T or F and then 2 T or F if you're not able to access the polls. Okay, so I think we'll go through the answers now. So the first question, men experience sexual harassment at work as much as women. You're sort of split on your response. It looks like 57% of you think it's true, 43% of you think it's false. The answer to this question based on reported statistics is false. So there was a 2018 survey done of Canadians, and in that survey, 52% of Canadian women reported experiencing sexual harassment in their working lives, whereas only 22% of men reported experiencing sexual harassment. And those statistics line up generally with the statistics that we know around sexual violence. So those statistics are broadly that 1 in 3 females will experience sexual violence in their lifetime, compared to 1 in 6 males. And another statistic that's important is that 1 in 2 trans-identified people will experience sexual violence in their lifetime. So, the workplace harassment fits in there. It's similar to those broad statistics, and it's important to note that anyone certainly can experience sexual harassment regardless of gender. It is still a common phenomenon for women in the workplace. And I'd also like to note that oftentimes when I'm talking about cases or sharing stories or examples, I refer to women, or I talk about she or her, but like I said, sexual harassment can certainly be experienced by anyone in the workplace, regardless of gender, and including non-binary folks as well. And another thing to keep in mind is that we only have access to statistics in order to answer these questions. So we can think about reasons why these statistics may not be certainly 100% accurate. Men may not feel comfortable reporting that they've experienced sexual harassment in the workplace, or they may not identify what they've experienced in the workplace to actually be sexual harassment. Okay, so our next true/false question, number 2, employees in the service industry experience the most sexual harassment. It looks like 80% of you thought that was true. This answer is actually false. The industry that has reported the most sexual harassment is actually workers in the health field, so healthcare workers, and and then the next industry is service industry, and then trades, and then education, law, and social services. So I will tell you, when I saw this question, I thought for sure the people working in the service industry, of course, must experience the most, because they're constantly around people, and they're providing services out in the public, and potentially just the more exposure, the more risk. But in speaking with clients that work in the healthcare field, you can think about some of the jobs are very vulnerable, and sometimes they're providing very intimate care, and they're providing care to folks who may be suffering from things like dementia, for example, which put them particularly at risk. And when I was presenting to a group of nurses and social workers, they said, we actually answered this question thinking of ourselves in healthcare as a service, as part of the service industry. So maybe the answer to this question is false, but it may be a little bit misleading. Okay, so number 3, workers have experienced an increase in sexual harassment during the pandemic. It looks like most of you thought this answer was false. The answer is actually true. So there was recently a study done in the US of workers across the US, service workers across the US, and many of those workers actually reported a dramatic increase in sexual harassment during the pandemic. And they reported an increase in things around, particularly when they were trying to enforce pandemic safety measures. So when they were asking customers to, use hand sanitizer, or to use a face covering, or social distance, this is when they were experiencing a significant increase. And also they were experiencing a significant increase in comments made by male customers. Things like comments like, take down your mask so I know how much to tip you, and take down your mask and show me your smile, and a significant increase in these types of sexualized comments. And there's also been an increase in online and virtual harassment. And I guess, you know, if you think about it, a lot of workers have gone to working virtually, working from home, and it does expose a little bit of vulnerability by the fact that like your colleagues can see into your home and they can see your personal space. And there has been an increased reporting of like online and virtual sexual harassment increases. So there actually has been an increase. Okay, so I'll put this answers up here. And before we go on, I do want to introduce my colleague. We know her by Cynthia. She also goes by Anome, and she's not able to. I think she's having some trouble with her with her audio, so she's not able to introduce herself. But Cynthia works at the clinic with us. She's an amazing person, and we're so thankful to have her. And I'm thankful that she's connected me with you folks and invited me to come speak to you. So thanks for joining us, Cynthia, and I'm sorry that you're not able to introduce yourself. Okay. So sexual harassment, we're going to talk about what sexual harassment is and what examples and what laws apply. But to note another statistic is we know that 52% of Canadian women have reported experiencing sexual harassment in their working lives. But of those 52% of women, 72% of those women said they never reported it. So we know it's a common problem. We know it's happening across all industries, but we also know for a variety of reasons that it's very unreported. Okay, so sexual harassment is harassment on the basis of sex, gender, sexual orientation, gender identity, or gender expression. And we'll talk a little bit about what all those things mean. But you know, and it exists broadly across these three different categories. So there's verbal sexual harassment, visual sexual harassment, and physical. And it can include a combination of all of these things. But typically behavior starts out as being like around verbal type sexual harassment, which can be jokes or intrusive questions or inappropriate comments. And if it goes unreported, then it can escalate and become like quite serious and up to including sexual assault. And we also know that sexual harassment, typically it's not about attraction, it's about discrimination, and it's about exerting power over somebody and a lack of respect for the victim in this situation. So we'll talk about these definitions, and these are all grounds that are protected under the Ontario Human Rights Code. And there's other grounds set out under the Human Rights Code, for example, race, ethnic origin, disability. Those are just a few examples, age. And we often see discrimination and harassment in the workplace with intersecting grounds. So someone may be being harassed based on their sex and their disability, for example, or their sex and their race. It often overlaps. So I'll just tell you briefly what some of these examples mean and how sexual harassment manifests in the workplace under these categories. And there's also a really great resource guide. We have an organization in Waterloo Region called Spectrum, and they're the 2S LGBTQ organization in our community, and they've created an amazing terminology guide. And so I'd encourage you to check it out if you have any questions or you're not sure what any of these things mean. They've got a really great resource there, and their organization also does a lot of really great things in the community. So sex is a category that people are assigned at birth, and it's largely based on genitalia or anatomy. And when we're talking about sexual harassment based on sex, that can include things like derogatory language or comments towards women, or sex-specific derogatory names. Like you can think of those names that sometimes are used in a derogatory way towards women, or any sort of comments or jokes around someone's perceived nonconformity with a sex role, like a stereotype, or a gender-based stereotype. So, like, for example, there was a case out of the Ontario Human Rights Tribunal a number of years ago where a woman was, she was the only woman working in a like a high-powered real estate organization, and she was doing her job similar to all her male colleagues, but because she was not conforming with those stereotypes around the way a woman should be in the workplace, she was just as aggressive as her male colleagues and just as assertive. She experienced a significant amount of bullying and harassment because of her behavior, and a lot of really derogatory comments made about her by her male colleagues, and that's an example of sex or gender-based sexual harassment in the workplace. So sexual orientation is someone's attraction to others. Sometimes it's commonly referred to as sexuality, and it can, some examples are if someone is gay, lesbian, straight, bisexual, pansexual, asexual, two-spirit, or more. And the way that we see sexual harassment manifest often in this category is around homophobic jokes. And I say jokes because they're not funny, but homophobic jokes or inappropriate comments, intrusive questioning about someone's sex life or their relationships, or inappropriate comments. And so we actually we know folks that are gay, lesbian, bisexual in the workplace experience very significantly higher rates of sexual harassment. And there's some really great cases out of the Ontario Human Rights Tribunal where high amounts of damages have been awarded to folks who've experienced homophobic bullying in the workplace. And so that's encouraging to see those cases coming out of the Human Rights Tribunal. So when we're talking about gender identity, this is someone's individual sense of their own gender that may or may not align with the gender that they've been assigned at birth. And we know that people's pronouns are often, but not always, tied to their gender identity. And there's been some recent cases from the Human Rights Tribunal in Ontario and in British Columbia, where the tribunals have ruled that misgendering someone in the workplace is a human rights violation, and it's discrimination and it's harassment. So in this case from British Columbia, there was a worker at a restaurant who told their coworkers that they use the pronouns they, them. And there was an older male colleague at the restaurant who refused to use those pronouns and made a lot of inappropriate comments, saying things like, this goes against what my grandfather fought for in the war, and you're not allowed to police my language. And he continued to use really gendered nicknames towards this coworker, things like sweetie and honey and sweetheart. And the Human Rights Tribunal said that that absolutely was discrimination, and those comments amounted to harassment. And that person was awarded $30,000 in damages from the British Columbia Human Rights Tribunal. So that it's good to see these cases which support and reinforce gender identity and protected pronouns within the workplace. And gender expression is how someone expresses their gender identity. So there's no right way to do that. And it can include things like hairstyles, clothing choices, accessories, or use or non-use of makeup. And employees they should feel safe to express their gender identity in the workplace however they see fit. And employers need to be really conscious about making safe and supportive workplaces. And that includes being conscious about things like dress codes, gendered dress codes, or gendered uniforms within the workplace. So we're going to talk just about a few different examples of these three categories of sexual harassment. So verbal sexual harassment, like I've been talking about, can include things like jokes, teasing, inappropriate comments about someone's clothing. So I think at the beginning we were talking about if you compliment somebody or something like that. Like if you think that you're complimenting somebody, but it's taken inappropriately on their end, it's very possible that something like that could amount to sexual harassment. So for example, there's a case which just recently was released at the Ontario Human Rights Tribunal. And in that case, it was an instance where 4 different comments were made. and they were found to amount to sexual harassment, and that person was actually fired from their job. And the Ontario Court of Appeal said that's okay. You know, this person, the man, was a long service employee. He'd worked at this company for 20 plus years. And normally when you've worked somewhere for a really long time, your employer may be a bit more hesitant to fire you, or the courts may be reluctant to find a termination. But in this case, the Court of Appeal said what happened here was sexual harassment, and the employer was allowed to fire this person. And so the comments in that case included jokes about, they were all directed towards the same female employee. And there was a joke about the person dancing on a table at a work event. And there was a joke about her getting on top of somebody and pinning them down to get information in a meeting. And then there was a joke, they were talking about their weekend, and she'd mentioned that she was gardening, and he'd made a joke about her being down on her knees. And every time he made these comments, she would say, you know, please don't, that's not appropriate, please cut it out. And she warned him, you know, like, if you keep it up, I'm going to report you. And one of the jokes was even made in front of a supervisor. And the male employee continued to make these comments, and he had a sort of an explanation for every comment, like what he meant something different. He didn't mean it the way it came out. But it did amount to sexual harassment, and he ultimately was terminated from his employment. So I think it's a good case because it highlights that even something like comments that are made that the person maybe just meant it as a joke, or he maybe didn't mean offense by it, but the woman was offended by these comments, and she let him know that they were not okay. And the employer did find those to be sexual harassment, as did the Court of Appeal. So even comments can amount to sexual harassment, which can get someone fired. And so if you've experienced comments in the workplace that are offensive to you or that aren't appropriate, I'd encourage you to think about your reporting options. You know, it's always great to let the person know that you're not comfortable with those types of comments or those types of jokes at the beginning. But if they're not taking it seriously and they're not stopping, then I'd encourage you to report those to your employer, and we'll talk about what your employer has to do. Visual sexual harassment can include things like staring, leering. I've heard from folks who've been shown pornography in the workplace by either their boss or their coworkers. I've heard from people who've had a boss or a coworker that just would stare at their breast throughout their entire conversation, or just make you feel very uncomfortable with their gaze in the workplace. Any sort of sharing any sort of sexually explicit content, or like printing it out and displaying it in the workplace, can constitute sexual harassment. Any sort of intimidating gestures, that all falls under this category. And physical sexual harassment, all of these behaviors include, there's a wide range of behaviors that can constitute sexual harassment. So physical sexual harassment can include things even like maybe giving you a hug in the workplace, or a massage, or it can include things that aren't overtly sexual, like maybe grabbing your arm or grabbing your leg. It can include things like following you around in the workplace, or even things like if someone's constantly brushing past you too closely and they say it's an accident, but it's not. And of course, up to including things like sexual assault. And so some of these behaviors that I'm talking about are behaviors that would constitute workplace sexual harassment, but some of them may also be criminal behavior, in which case you may want to be talking to a police officer and maybe pressing charges, particularly if we're talking about things like stalking or criminal harassment or sexual assault, and it veers into that criminal conduct. And there was also a case recently out of the Court of Appeal of Ontario, which there was only one act of physical touching, sexual touching. And in that case, that employee was terminated, and the Court of Appeal upheld that termination. So in that case, again, it was a long service employee. It was a man who'd worked at his company for 20 plus years. He was in a management position, which was a factor in leaning towards his termination. And he slapped his coworker on the buttocks, and he was ultimately terminated. And some of the factors that went into his termination were the fact that he didn't take the conduct seriously. So when he was investigated, he made a lot of comments about how there was like a sexualized work environment, and there was a lot of banter that went back and forth. And he compared the butt slap to like punching his coworker in the shoulder. So he didn't acknowledge the sexual nature of the behavior. And then also he'd recently had sexual harassment training, and he was in a position where he was, as a manager, supposed to be facilitating a work culture and a safe work environment. And he was supposed to be promoting the policy, the workplace harassment policy, and instead his behaviors went against that. So he was ultimately terminated. And it's good to see cases coming out where something like a one-time incident, something like that can lead to a termination. So it's good to see that the courts are taking this behavior seriously. What laws apply? It depends on if you're a provincially regulated worker or a federally regulated worker. And we're going to talk about the provincial laws today because most people are provincially regulated, but the federally regulated workers are people who work for broadcasting or telecommunications. So if you work for Rogers or Bell, if you work at a bank, you might be federally regulated. If you work for Canada Post, or if you work for an airline company, or if you work for a trucking company that goes across province, or if you work for the RCMP or the military, for example, then you would be a federally regulated worker and you'd have different laws that apply to you. The protections are generally the same though. But most folks are provincially regulated, and the protections are set out under the Occupational Health and Safety Act and the Ontario Human Rights Code. And we'll talk more about those laws. There's also protections in the Workplace Safety and Insurance Act. So if you are injured on the job because of harassment, and that could be a physical injury, maybe from a sexual assault, for example, or it can even be a mental health injury. If you experience something like post-traumatic stress disorder, PTSD, as a result of the harassment you've experienced in the workplace, it's possible you can bring a WSIB claim and get compensation or benefits through that program. And we can talk a little bit more about that as well. So the Occupational Health and Safety Act, this is legislation in Ontario, and most provinces across Canada have similar health and safety legislation. And it defines sexual harassment as engaging in a course of behavior against a worker in a workplace because of their sex, sexual orientation, gender identity, or gender expression, where that behavior is either known or ought to be known to be unwelcome. And so the things to take away from this definition are that it's talking about a course of behavior. So typically that means more than one incident. Although, like we were just talking about, a one-time incident certainly can constitute sexual harassment. So like a physical act certainly can, one-time physical act certainly can constitute sexual harassment. If there's a one-time joke or a one-time inappropriate comment, that may not necessarily rise to the level of meeting this definition. It may be something where your employer is deciding they're going to talk to you about it, but maybe it doesn't necessarily amount to sexual harassment. This is typically talking about a pattern of behavior or a series of behavior. The other important thing is that it's talking about behavior that's either known or ought to be known to be unwelcome. And so what that means is if you are asking someone questions about their personal life or their relationship, or you're making comments about their physical appearance, and you don't personally know that behavior is unwelcome, but most reasonable folks in the workplace would know that that's not welcome behavior, then that can constitute sexual harassment. So when we're talking about human rights violations and when we're talking about sexual harassment and discrimination, it's not really about the intention of the person that's doing it. So maybe you're making these comments and you're just intending to be fun and flirty, but it's about the impact that it's having on the person. So if the person feels uncomfortable, they feel insecure, they feel unsafe in their workplace, then that's what these laws are getting at, and that's what they're designed to provide protections for. if you're bringing a human rights claim, you don't have to prove someone's intention, because it's not about their intent. So the second part of this definition, B here, making a sexual advance or solicitation where a person is in a position to grant or deny a benefit. This is when someone's in a position of power or position of authority. So if there's a manager or a supervisor and they are, saying, go on a date with me and I'll give you a raise, or I'll give you all the really good shifts, or, have sex with me, or if you don't, I'm going to fire you, for example. That's what these comments, that's what this part of the definition is getting at, to protect those folks in the workplace. So the Human Rights Code sets out the same definition. It has the same definition of sexual harassment as the Occupational Health and Safety Act, but it finds sexual harassment to be a form of discrimination. And it also explicitly states that people have the right to a harassment-free workplace. And under both the Occupational Health and Safety Act and the Human Rights Code, people are protected from what's called a reprisal. And so what that means is, if you make a complaint, so if you go to your boss and you say, this person is harassing me, and as a result, you experience any sort of, if you experience any sort of threat, or if your employment is terminated, or your hours are cut, or anything bad happens to you as a result of making that complaint, then there's specific remedies you can seek at the Human Rights Tribunal. There's this, because your employer is not supposed to do that. They're not supposed to punish you in any way for making these complaints. You are entitled to make complaints about these things. So these protections that are set out in the law are very broad. They apply to you regardless of who is doing the harassing. So, you may have a boss that's harassing you, or a coworker, but you may work somewhere where you have a client or a customer that's harassing you, or maybe the organization has volunteers and they're harassing you, or if it's a small family company and your boss's spouse is harassing you, anyone related in any way to the employment, if they're doing the harassing, then you're protected. Similarly, you don't have to be a full-time permanent employee in order to be protected. If you're a part-time employee or a co-op student, or you're volunteering somewhere and you're experiencing harassment, you are protected by these laws. And also, you don't even have to officially be an employee. So if you are going on a job interview, or you're being recruited, you're going to a recruitment event or any sort of job training before you even officially start somewhere, and you're experiencing harassment at any of those stages, the laws apply there as well. And in order for it to constitute the workplace, it just has to have a connection to the workplace. So this is also very broadly defined in the legislation and in case law. And so some examples of having a connection to the workplace would be if your whole workplace is going somewhere for a training event or a social event. Maybe you're all going out to a restaurant together, or you're all going out to a bar together, and you're experiencing harassment at that physical space that's not your workplace. That can certainly have a connection to the workplace enough to constitute workplace sexual harassment. Or if you go home at the end of the day and you're getting text messages or calls from a boss or a colleague, that can have a connection to the workplace, even though it's not physically happening in your actual workplace. Or, like I said, we've heard of a significant increase from workers who are experiencing virtual sexual harassment now that people are working from home. Harassment can be being done online in a variety of forms, and including over social media. So if you're experiencing anything, but you're not sure if it's actually connected to the workplace, I'd be happy to chat about it. Like I said, it's quite broad. So it includes and encompasses a lot of different things aside from just being physically harassed in your physical workspace. So your employer has a number of obligations set out in the Occupational Health and Safety Act about things that they need to do to keep their workers safe. So they have to have a policy, and the policy has to set out how they're going to respond and deal with complaints of harassment. They're supposed to provide training to their staff they're supposed to make their policy readily available to all their workers. So ideally, when you start somewhere, you should be given a copy of the policy, or you should be told where the policy is and what steps you can take. If a complaint is made to the employer, they also have an obligation to investigate. So your employer is not allowed to sweep these things under the rug. They're supposed to look into it. And there's certain things that they should do when they're investigating. So, if you're the person that's made the complaint, they should talk to you about your complaint. They should ask you questions and give you a chance to give your side of the story. They're also supposed to talk to the person that the complaint is made against and give them an opportunity to respond. And they're also supposed to talk to if there's been any witnesses that are identified. So, if you make a complaint to your employer and they say, oh yeah, we'll look into it, and they don't, there's certain things you can do. Or if they say, we looked into it and we don't think that that's sexual harassment, but they didn't talk to you, or you told them about a witness and they didn't talk to your witness, then there's other steps you can take if that's happening. So they are supposed to investigate. They have an obligation to investigate, and they also have an obligation to let you know the results of that investigation. So you're entitled to know what they found and what they're doing about it. They're also supposed to do what they can to ensure the privacy of everyone involved. That's sometimes tricky. It's sometimes easier said than done, particularly if it's a small workplace, but your employer is supposed to do what they can to make sure that people's privacy is protected. And so if you've experienced sexual harassment, these are things you can do within your workplace. First of all, the first steps to take would be, if it's safe to do so, talk to the person that's making the comments or the jokes. If I appreciate that that's not always something that's safe or possible for folks to do. So, and you don't have to do that in order to make a complaint. It's just a suggestion if you can. Having a support person that you can talk to about these things is also really important, because making complaints or experiencing sexual harassment can be very difficult for folks that are experiencing it. So having someone that can support you in that process is important. So the steps you'd want to take would be to find out what your workplace policy says about harassment and to take the steps to report it. And it's not enough to just tell your supervisor or your manager that you've experienced sexual harassment. You want to follow that up in writing. And it's really important that you keep a record at home about everything. So write down as much as you can about the harassment, document everything. Who's doing the harassing, what's being said or done, dates, times, is there anyone around? So document all that, but also document any of the steps you've taken to report the harassment to your employer. So if you told the supervisor about it, write down the date and the supervisor's name. And if you're putting your complaint in writing and submitting that to a supervisor, make sure you're writing down for yourself all of those details. And it's also possible, like we were talking about just a moment ago, you can insist that your employer investigate. They do have to do an investigation. And you can insist that you're told the outcome of that investigation. And if there's any consequences, you're entitled to know the nature of those consequences as well. Unfortunately, you're not entitled to a specific consequence. So oftentimes people will want the perpetrator to be fired. And unfortunately, there's nothing in the law that says you're entitled to a specific remedy. But I always encourage people to let your employer know what it is you're looking for ultimately. So if you want to be moved to a different shift, or if you want the perpetrator to be moved to a different shift, or you want them to be trained, or you want to report to a different supervisor or anything like that, let your employer know what you're seeking, because then they'll know how serious it is and the impact that it's having on your life. And then if you've taken all of those steps and you've tried to address it with your employer, and they're not taking it seriously, or it's not, things aren't changing, or if you work in a place where the person that's harassing you would be like the person that owns the company, so you don't have anyone else to make a complaint to, there's other steps you can take. Always, I'd say, get legal advice, contact me, or if you live in a different community, contact your local community legal clinic, because there's someone there that would be happy to give you free advice about this. If you've experienced, stalking or sexual assault in the workplace, you may want to think about contacting the police. And if you work somewhere that's unionized, that's a really great place to start as well, talking to your union rep, letting them know what steps you've taken and what you're looking for, because they can help you be your advocate in the workplace. And then if all else fails, and it's possible you can make a complaint to the Ministry of Labor if your employer doesn't have a policy or if they're not conducting an investigation. So you can go to the Ministry of Labor about that. If at any point you can bring a claim against the person that's harassing you to the Human Rights Tribunal, or you can possibly bring a claim against your employer if they're aware of the harassment and they're not doing anything to remedy it. But you only have 1 year to bring a claim to the Human Rights Tribunal. So that's a really important timeline to keep in mind, because I often hear from clients that don't realize that they have only 1 year, and they'll come to me a few years after the fact, and they're unfortunately out of time. So keep that timeline in mind. You only have 1 year to go to the Human Rights Tribunal. You only have 2 years to go to court from the last incident of harassment. So if you want to ultimately sue your employer, you only have up to 2 years to do that. And then the shortest timeline is if you want to make a WSIB complaint. This is if you've experienced an injury, if you've been sexually assaulted at work, or if, like I was talking about before, if the harassment leads you to getting an emotional or mental health injury like PTSD, it's possible you can bring a WSIB complaint claim, but you only have 6 months to bring those types of claims. So there are some sort of tight timelines, and you do have to take legal action relatively quickly if you are experiencing these things. So I want to leave time for questions. So I think this scenario is really great. So I think we'll go through it, and then if folks want to hang around, I'm happy to hang around for a little bit after to answer any questions that people might have. So I'm going to read this one. It's kind of long, but the things that I want you to keep in mind when we're going through is, does this sound like sexual harassment to you based on that definition that we talked about? Does it sound like these things are happening in the workplace? And I have a few other questions I'll ask you after. So Mary worked as a waitress in a restaurant. Bill was her supervisor, and he was responsible for shift scheduling. The work environment at the restaurant was sexually charged, and there was a lot of sexual banter. So then the following incidents happened. So during an after-hours event with coworkers, Bill said that he could guess what women's breasts looked like, including Mary's. Mary never made a complaint about those comments. Mary went to the restaurant one day when she was not scheduled to work in order to ask Bill for a night off. Bill said she could have the shift off if she found a replacement. Bill later said that Mary offered to show him her breasts to get time off. She denied that. Bill sent a text message to Mary saying he had a dream where he asked to see her breasts, and she invited him to have a shower with her. He described the dream as very detailed and strangely awesome. Bill then left a voice message for Mary around 3:46 a.m., which contained graphic sexual depictions about her. And he left this message while he was having a party at his home with several male staff members from the restaurant. After that voicemail message, Mary didn't go back to work. She stopped going to work, no further communications with Bill, as she felt very creeped out by all of it. So the series of events that took place between Mary and Bill, I guess I'm hoping that people will feel comfortable to go off mute, or if you want to raise your hand or put your answers in the chat. But do you think that these comments that are being made by Bill, first of all, that are taking place, is this something that would constitute the workplace? Are these things happening in the workplace? So the first one's during an after hours event. And then he's sending a text message to her and leaving her a voicemail. So are these things that are taking place in the workplace? What do you think? What do folks think? I don't know if anyone feels comfortable.
Hi.
Hi.
So I still think even though it happened outside of Mary's work hours, it did impact Mary's ability to do her work properly. and it actually, there's some damage to her image as well. So I would say that it's sexual harassment at the workplace.
Thanks for sharing. I think you're right. Does anyone else think differently? So I can tell you that what the law says is it has to have a connection to the workplace, and it's very broad. So the fact that they're having an after hours event at work, even though it's after hours, if it's an event where Mary felt like she needed to go, or she felt any sort of obligation to attend, or if it's happening, does it say that it's happening in that physical workplace? Maybe it's happening in the restaurant after her shift, or the fact that Bill has her personal cell phone because of a work-related reason, but he's using it for an inappropriate reason. All of these things certainly can constitute the workplace. So I would agree, even though maybe it's not happening in the physical workplace, some of these comments are happening on the phone or through text messages, that is a sufficient connection to the workplace, definitely. Okay, so then my next question is, you know what, I think I might skip to the next slide so you guys can see the question. So did Bill know, or ought he reasonably to have known, that his comments or advances were unwelcome? What do you think about that? So we know that she didn't complain. So the first comments that were made at the after hours event about her breasts, like it said specifically that she didn't complain, but do you think that he ought to have known that those comments were unwelcome? What do folks think about that?
To answer this one, I would ask. I don't know if this is a real incident, but hypothetically, has Bill gone through the company policy around sexual harassment, or does the company even have one? And well, did Mary at any point object or say no, or say I don't like what's happening, or you know what I mean? Like those situations might help understand Bill's position here.
Yeah, those are good questions. I mean, I think we can, so this is based on a case from the Ontario Human Rights Tribunal. I think we can assume that the employer has a policy, because most employers are obligated to have a policy. And we know that she didn't officially complain about, or she didn't explicitly say that those comments were unwelcome. But I think it's probably safe to say that he ought to have known that those comments or advances were unwelcome, because in a reasonable workplace, most folks know they shouldn't be making comments about women's breasts in the workplace, or sending sexualized comments or voicemails to their coworkers. So I think, you know, even if she didn't say, please stop, this certainly can still constitute sexual harassment, because a reasonable person will know that's not okay, it's not welcome. And particularly, well, I guess we don't know the nature of the sexualized comments, but he's talking about her breasts, he's talking about having a shower with her. All of these things would certainly could certainly constitute sexual harassment, even if she didn't specifically say not to or tell him to stop. Okay, so what do folks think about the third question? Sorry, and I see I see some messages in the chat. Yes, I consider it as sexual harassment. You seem not to care about what her thoughts are. Yeah, exactly. And I think thank you for that, and I agree. And I think the fact that it's happening, you know, at something like 3 a.m. in the morning while he's having a party with some of his other coworkers, all of those things would tip it towards just being incredibly inappropriate and unwelcome. So what do folks think about number 3? Do you think she quit? So what we know from the facts are that after he left that voice message for her, she stopped going to work. She was very creeped out and she stopped going to work. So do you think she quit? And what do you think the law says about that? She probably quit.
Yeah, I'm Jeff here.
Hi.
I would have said Mary didn't quit because she did not formally inform the employer of what is happening. And I don't know if the employer have the policy or a procedure of reporting sexual harassment at the workplace. And
Right.
if Mary is also aware of what is the procedure, right? So I think Mary is not reporting this issue to the senior management of the organization or the employer, I think Mary is doing something wrong also.
Okay, thanks. Yeah, so if Mary was my client, I certainly would have tried to encourage her to report this before, stopping going into work if it's possible. But it might be a situation where the person that she maybe Bill is the person that she would be reporting to, and then that becomes really tricky because she can't report him to him. So what this is getting at is that we have a concept in law called a constructive dismissal. And so essentially, if your workplace becomes very toxic and very hostile and you can't go to work anymore, you can quit your job and then you sue your employer as if you've been fired or terminated. So you can seek some compensation in that case. I would say the fact that Bill is her supervisor, she would report to him in the workplace, and the fact that he's leaving late night inappropriate sexual voicemails for her, all of that behavior put together certainly can constitute what's called a poisoned work environment, and Mary can quit and then sue, or she can quit and then still seek employment insurance. And she would argue that she is entitled to employment insurance. She didn't quit her job. She had to quit her job essentially because of this poisoned work environment. So thank you for sharing. And I'm not sure, I see this comment which says what he said was away from the focus of the job. Do you want to elaborate on your comment a little bit? Or you feel comfortable, or?
Well, what I meant is that for such comments, anything that is, because the job basically for a restaurant, everything has to do with what you're doing in the restaurant. It could be issues of recipe, customers, and everything, and it should be more of customer focus or business focus. But there's something we call it mixing business with pleasure. Once you start mixing business with pleasure, I think that's where issues of harassment comes in, because there's nothing that our breasts, our body does not have anything to do with our job. So
Right.
That's why I said it's off track. So it's trying to mix business with pleasure, which is wrong.
Yep. Yeah, you're right. Thanks for sharing. I mean, even if he made these comments during working hours, like on the job during working hours, they would still constitute sexual harassment because of the nature of the comments. But yes, you're right. Like that it's happening after hours, and the nature of the comments certainly make it all constitute sexual harassment. And so I'm sorry, I know we're over time. I don't know if folks want to keep talking, but like if anyone feels comfortable sharing, what steps do you think she could take? So I know I heard from some of you saying, we don't know if she has a policy. She probably should be reporting to senior management. So we know that, and I agree. What else do you think you could recommend for Mary? What other steps could she maybe take at this point? Yeah, great. Thank you. Proper documentation of what happened is necessary. Documentation, right? I'm glad that point has come across. Documenting everything is huge. So if Mary was my client, I'd be saying, I'd be encouraging her from like the very first time one of those inappropriate comments is being made for her to be jotting it down in a diary or a journal or making an email to herself or any sort of way to document that. Is every time something inappropriate is being said, writing all of that down. So yes, absolutely documenting. And then, you know, getting legal advice so she can know about what her options are and what timeline she has in order to be bringing some claims. So this would be a situation where I'd be reporting to the Human Rights Tribunal. Exactly. I'd be suggesting that Mary consider possibly bringing a human rights claim or a court claim seeking constructive dismissal damages, because she did end up having to quit her employment. So there's human rights issues, and then there's loss of earnings, loss of the potential to earn money because she had to leave that employment. So there's other types of remedies she could be seeking as well. Maybe I'd suggest she consider applying for employment insurance, and thinking about the steps to take for legal action. So thank you everyone for participating. This is my email address is here, and I'm also going to put it in the chat. But if anyone has questions, I'd be happy to answer them. And I've got a resource slide, which I'll put up as well.